24899 Bhim Sharkar, is your application for addition of party there?
It's allowed, my lady.
It's there. You have an application over there.
Yes.
All right. And what is your status?
Yes, my lady, we are untainted.
All
And I
right.
say teachers because I want to. I say teachers because we are presently teaching in the government school system all over this state. And we have been teaching so for almost 7 years. So, in that sense, we form a backbone of education in government schools in the state of West Bengal. Now, in 2016, because my lady had posed this question on Friday, and these are the numbers, because my lady must have the big picture of what you're hearing today.
Yes.
In 2016, there were 18,617 vacancies. I want the table of all the cans where appearing. Get me that. 18,617. In 2025, there are 35,657 vacancies that were advertised by the government. Now, why are these numbers important? Because amongst the various petitions, my lady is also seized of petitions by freshers, meaning applicants in that classical sense, who are applying for the first time and took the 2025 exam subsequent to the decision of the Honorable Supreme Court and cleared that exam. Now, this court is seized of a situation which is highly unusual, because it is a rare case where a court is seized of a situation where you have existing members in a service and entirely fresh members in a service taking the same exam. It never happens. So my lady is seized of a unique situation which amplifies service law, constitutional law, administrative law, and of course with the CBI investigating criminal law. But in the realm of constitutional and service law, you rarely have a case where existing personnel have to take the exam which they cleared 7 years before again for no fault of theirs. So when I present myself to you, who do I represent? I represent an individual who has 4 qualities. 1, I am entirely untainted. I have indulged in no wrongdoing, firstly. 2, I have been performing my job with honor and rigor. Why do I say this? Because not only have I been teaching for now almost 7 years, but my lady knows well the multifarious obligations and functions of a school teacher: election duty, invigilation duty,
Yes.
and so forth.
Right.
So one of the many petitioners I represent, and there are 13,000 such teachers. One could not be today in court because he's doing invigilation duty for an exam. While he is teaching, he has also done invigilation and he has taken the exam afresh for no fault of his. Now, in 2016, if my lady will just make a note of this, 17,209 teachers were appointed, tainted and untainted. In the 2016 teachers who appeared in the 2025 exam, the untainted, is 13,800. And I speak for a substantial majority of all of them. Now, you have had, just to, again, who is taking this exam? Since we are here, multifarious categories, all arguing different aspects of the rules. And my lady is seized of the virus of the rules. That is what is before my lady. Fresh candidates, just to give you a sense, for grades 9 and 10, fresh candidates, 2,70,000 applicants, candidates who appear. And for 11 and 12, 2,18,000. And many of these overlap between 9 and 10 and 11 and 12. That is to give you a sense of the magnitude that is the exam, the number of young people who apply for this exam, and in so many ways, all these young people, whether they are freshers, whether they are not so young, the existing teachers who form the backbone of education in this state, have all been let down by this process of examination, recruitment, and eventually that we are before my lady. Because rare is the case when the innocent have to suffer the trials and tribulations of adjudication twice over. It is a rare case. In criminal law, we say no double jeopardy. In service law, we have no language for it. But that is who I am and how I am before my lady. Now, the first point I want to make, my lady, and I'll demonstrate that through the data, is this. Is that one, the number of vacancies today under the 2025 process is almost double than what it was pursuant to the 2016 process. In fact, in the Supreme Court on Thursday, Justice Sanjay Kumar was hearing this case and reposed confidence in my lady to hear all issues correctly. Made this point that I never expected the state government to reopen the process to fresh candidates. I thought you would only, in fact, have this exam for those who are teaching and untainted. That was his case. So that was the element of surprise. But that has been now dealt with by the fact that you have almost double the number of vacancies. And I will take my lady through the data to show that a substantial percentage of those who succeed through the exam system in 2025 are freshers. So they are not burdened by the 10-mark rule, which I will subsequently argue is rightly been given by the state in this context. And why do I say that it is rightly been given? Because, my lady, there is great value to teaching experience. And the teaching experience in this case of 7 years means you have a super qualified teacher who has 7 years of experience in the classroom. Mathematically, I was trying to put a number to this. What does this mean to have 7 years experience? Because it is very difficult for a court, which is not an expert body, engaging what is the most efficacious teacher. But mathematically, what does this mean? This means that if you have roughly 13,000 existing untainted teachers who've been teaching for 7 years, teaching roughly 225 days of the year with holidays, etc., into 8 hours, you would get an extraordinary number of 14 crores 4 lakh teaching hours that these 13,000 candidates have between themselves. And I should say these 13,000 teachers have between themselves. And what does that mean in terms of enhanced efficaciousness in the classroom? We can imagine what that means.
No, that means you are supporting the extra
Yes,
prior.
yes.
Yes, I get it.
I am
Then,
supporting the extra
Then
10
what?
marks, which is 2 marks per year of teaching.
right.
And so at 7 years, I'm actually not getting 2 marks per year. I'm only getting marks
For
for
5
5 years. And that is only being counted once, not twice, not thrice, but exactly once. I'll go to the rules subsequently.
And you are for the 9, 10 or the 11, 12 batches?
Both, my lady.
Right.
9, 10, 11, 12.
All right.
This is who I'm for.
How
Now-
do you substantiate the allegation that your experience in 9 and 10 is being counted for 11 and 12?
My lady, the experience that the rules contemplate, and I'll take you to the rules in specific immediately. The experience that the rules contemplate is experience within the classroom of higher secondary. There is not a great, because the nature of the teaching experience is also subject specific. I'm going to take you to that to show you how the intake is also subject specific. So in that sense, there is no great difference because the subject specificity is also there. In fact, I want to show you what I'm actually discussing. Can I just have this? Yes. I want to see the subject. So firstly, my lady, may I just hand over? This is the preliminary interview panel. We've just picked this ad hoc 11 and 12. My lady has this.
Yes.
This is the preliminary interview panel, SLTS 11 and 12. I've just picked 11 and 12. Equally so, we can show my lady 9 and 10. Freshers versus in-service ratio percent. I'm going to make good on my claim that anyway, the freshers are protected. Please see. You'll see that the intake is subject specific. For instance, there is accountancy, agriculture. These are all specific subjects that are offered by the schooling system, 9 to 12. And I have to demonstrate expertise in this. Now, please see, for instance, since it's at top of the list, accountancy. 92.86% of those who successfully get to the interview panel, meaning clearing the exam, demonstrating qualifications, are freshers. Only 7.14% are those with experience like me, untainted, experienced teachers. So, similarly, my lady, please appreciate the entire list before you. These are all the subjects that are offered in the higher secondary schooling system. Agriculture, 66% of those before the interview panel are freshers. Likewise, if I randomly pick economics,
Agriculture is not there in 9 and 10. Agronomy is not there. Anthropology is not there.
11 and 12. This is what I'm
Right.
demonstrating to you is 11
So
and 12.
11 and 12
Yes.
experience is all right.
Yes.
But somebody in classes 9 and 10,
Yes.
how can experience marks be counted for 11 and 12?
Because what is the nature of what the rules contemplate to be experience is the experience of having taught students in the classroom. That is what
Does
the
it mean?
rules.
Does it mean? Suppose I have taught 5, 6, 7. The
It would not, my lady. Respectfully,
yes,
it would not.
it will not
Because
be.
the
Primary classes experience,
yes,
secondary classes,
primary,
the upper
middle
primary
school,
is different.
and high school or
Yes.
higher secondary school. Higher secondary school is classically 9 to 12.
Higher secondary starts from 11 and 12.
Yeah, no, my lady. 9, 10, 11, 12
9,
is what
10 is secondary.
May I just take you to the rules? Secondary. May I
9 and 10 is secondary.
Yes, may I just take you to the rules now? May I just take you to the rules? Yes, I want to. Which SLP? My lady, would my lady have the compilation that I'd handed over last week?
There in Vim Kumar.
It's in
In which matter did you hand it over?
Vim Kumar.
Vim Kumar.
This spiral one.
This spiral one, which is just next to you.
In this? দেখি তো ওর একটা compilation আছে।
We can just hand over another copy.
দাঁড়ান দাঁড়ান দাঁড়ান, এটাতেই আছে বোধহয়। ওই বড়টা দেখাচ্ছে তো, এটাই হবে নিশ্চয়ই। দেখি দেখি একটু ঘোরান সেলাইটা দেখি। না না, এটা অন্য লোক দিয়েছিল। Do you have a back sheet? Is it under a back sheet? No, I don't know.
No, my lady. But we have another copy of the same compilation that we handed over.
Let me see once if it is here.
Spiral bound. No. It was
ওটা দেখুন না, ওটা কত মোটা। না না, এগুলো নয়, ওগুলো নয়, ওগুলো নয়।
Yes.
ওগুলো নয়।
It's page 503.
ওইটার নিচে কিছু নেই? নীলগুলোর নিচে? নীলটার নিচে কি আছে? Voluminous one. In which matter did you tag
In
this
Vim
up
Kumar,
with?
Vim Kumar, my lady.
This is, I am having Vim Kumar with me.
It was put away in a very nice red colored.
Oh, it was also.
spiral.
I think this may be it. This it? Let me just see. No, my lady, this one.
No.
This is Vim Kumar, but this is not the compilation. And my lady had marked up also
দেখি, দেখি,
passages in it.
তারপরেরটা?
Mandal.
Is it the convenience compilation? This one?
Yes, my lady.
Yes.
Yes, my lady. Yes.
All with the blue sheet. That is the reason it got
the
mixed
blue
up.
sheet. Convenience compilation of judgments and documents.
Yes.
Now, may I just take you to page 503?
Yes.
And this is the main statute, West Bengal Board of Secondary Education Act 1963.
Yes.
And may I just take you to page 503?
Yes.
The definition of secondary education. And this is all I seek to rely on. My lady has page
Yes,
503. I should actually say H on 502 is primary education. And secondary education, my lady has that 503L, KL, means general education above the primary education stage provided for students with a view to qualifying them for admission to a certificate, diploma or degree course instituted by a university or by government or by a statutory body and includes subject to any general or special order of the state government, technical, agricultural, commercial, so on and so forth, or any other type of education which the state government may, in consultation with the board, specify. Now, may I take you to 547? This is the schedule.
Yes.
So, my lady, this is the generic understanding of secondary education. I would respectfully submit that this would constitute 9, 10, 11, and 12.
Secondary.
Secondary education.
All right.
Secondary education. Now, please see the page 547. My lady has that.
Yes.
Schedule 2.
Right.
Please see. Schedule 2. Now, the first segment of the schedule is with reference to classes 9 and 10. May I read? Selection to the post of assistant teacher for classes 9 and 10 shall be made on the basis of marks obtained in written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration determined by the Central Commission in the following manner. I'll just stop here for a second. Now, earlier in the morning, one of my learned friends actually makes this point before my lady, that this is the first time that prior teaching experience is part of the rules and delegated legislation. Now, the answer to that is, but obviously, my lady, because this is the first time that existing teachers who have taught are being forced to take an exam again for no fault of theirs. So the rules are in response to the reality that is the situation that faces the state and my clients, the untainted teachers. You could not have contemplated this situation. I mean, I suppose if you had been more diligent about the system itself, then we wouldn't be in this unimagined situation. I should say that. So therefore, the rules which are passed keeping in view the Supreme Court's judgment and the related situation of recruitment for the posts of teachers, and I know staff are also before my lady, but I'm only on teachers, was uncontemplated. The rules then had to be passed to address the judgment of the Supreme Court and the situation that I find myself in today. So it is not a surprise at all, nor is it of any relevance, that the rules in the past did not have this language. So that is my second point. Now may I continue reading?
Right.
So selection to the post of assistant teachers for classes 9 and 10 shall be made on the basis of marks obtained in written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration determined by the Central Commission in the following manner. Written examination, that is OMR based, 60 marks. Academics. Now, this is the crucial phraseology. Academics is part 2 of Schedule A2 now. A2 has 2 ingredients. Under the subtitle, the subchapterization of academics. A, educational qualification, 10 marks. Based on marks of graduation or post-graduation in the subject for which applied, whichever is higher, according to the following formula. So within educational qualification, the 10 marks are given. There is a meritorious component to it, which is tied to the percentage you've obtained. So this is explicitly tied to the percentage you've obtained. So for instance, may I just show you a sheet of who are some of the untainted candidates to just give expression to what this component means. Can I just have that sheet? Yeah. Where it shows the marks they received. And
No, how does it matter?
yes, it matters because in the wisdom of the legislature, we are assessing when my lady is seized of the virus of the schedule and the virus of the statute. My lady is being asked to address and assess and adjudicate upon the wisdom of the legislature. And in the wisdom of the legislator, it is not only 2 classes that are created of those with prior teaching experience and those without prior teaching experience. There are a manifold classes that are created in these rules. Please, so we cannot only look at one categorization independently and in vacuum. The legislature and the executive, because they rightfully have the expertise, are creating a hierarchy of preference. One of the preferences is what is the percentage you have received in your written examinations, and that we call educational qualification. And you will see that, of course, classification is created here. That classification is if you have received 60% and above, you get 10 marks. Now, somebody who gets below 50% is disadvantaged because they only get 6 marks. But that is the space and the sanctity we accord the legislature and the executive, who in turn have experts to advise them in terms of how and what they should prioritize. So they are not just creating one zone of priority, which is past teaching experience as a teacher and no teaching experience. They are creating many zones of priority. Now, when the legislature and the executive creates manifold zones of priority, what does the Constitution say to this? The Constitution, after all, assesses. We are not Britain, where Parliament is supreme. We are India, where there is separation of powers. And the Constitution then is expected to look at the objectives of the legislature. And the only test which my lady, I would respectfully submit, would in fact take into account is whether the rationale is, the objective is rational. And here you will see that the rules and Schedule 2 creates a manifold sense of priority and preference and hierarchy and whatever we may call it. The first one, my lady, is merit score in terms of educational qualification. Now we come to the second one, but not the only one. And I will take my lady to the third and the fourth. Now we come to the second one. Again, is this rational? Is at best the only lens that the court can, in fact, look at it with. Because anything beyond that you would traverse into the area of expertise, which respectfully, my lady, because I certainly don't have it, nothing in legal education prepares you to assess what makes a perfect teacher and what makes a better teacher. Because when we enter into that realm, which respectfully separation of powers prohibits us in the legal domain from doing so, we are entering into a debate that then should extend to what makes a better pilot in the armed forces, what makes a better general in the army, and what makes a better surgeon in government hospitals. This is a realm which the court has never navigated. because of, my lady,
Lack of expertise.
judges are full of wisdom, but maybe not expertise in recruitment requirements.
Yes.
That's all, with great respect. That is as far as I want to go on that. But there are two arguments that I'm presenting. And at the end, my lady, when my lady reserves judgment, I'll submit a note. But the two arguments that I'm presenting before you is one, my lady, that prior teaching experience is not the only classification. And two, my lady, that this, what constitutes preference and priority for the recruiter, in this case, the employer, in this case, the commission, is for them to decide. The courts are very capable of looking at a recruitment system and saying, is there fraud? Is there cheating? Absolutely. That is the domain of the judiciary. But this, my lady, respectfully falls outside the realm of separation of powers, outside the realm of expertise, and outside the realm of what a court can assess. Now let's go to the third step of why courts don't have expertise. Courts don't have expertise because, one, they are not fed with the raw data of how many vacancies. Two, they are not fed with the raw data of what makes a better teacher. Three, they are not fed with the raw data of what all functions teachers have to navigate. So the experienced teacher right now, one of my clients, is out having taught in the morning, invigilating in the afternoon, worrying about his court case in the evening, and also having written the exam again. This is all that experience gives him the tools to navigate. And there is value in that experience. I have only very crudely given it a numeric value, 14 crore teaching hours. Ought that not to have value? And does the legislature not have within the constitutional scheme the ability to ascribe enhanced value to it? Respectfully, my lady, a court will not be able to assess what it means to have that value. But is it a rational objective for the court to say, yes, this is rational in terms of better returns, better efficaciousness in teaching, and in fact, in spirit also, implementation of the Right to Education Act? Is that object rational? As long as it is a rational object, my lady, respectfully, the court must then demur from there.
All right.
Yes. And my lady, respectfully, I'll take my lady very briefly to Arunima Pal, where the court says that. And my lady is right on the general discussion, some of which may be obiter. Absolutely, I bow down, and I think that debate has been set aside. But on how and who has expertise, the division bench in Arunima Pal provides some light. Now, may I take you to the third criterion in Schedule 2. Oral interview, 10 marks. Yes, my lady, before I go any further, prior teaching experience, 10 marks. At the secondary level, in a government or government-aided or government-sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or on contractual basis. No doubt, my lady, you will have petitions on permanent and contractual also. I'm not on that right now. Now, please see criterion 3. Oral interview, 10 marks. 4, lecture demonstration, 10 marks. Appearance before the interview board is compulsory. So in this realm of academics, because the language and the terminology has repeatedly been contested before my lady, in this realm of academics, there are only 2 components. 1, educational qualifications, meaning prior, and 2, prior teaching experience. What is interesting about the component that is academics is both of it pertains to prior conduct before the exam. And that is where both these components are in consonance and in harmony. That is the intention of the legislature. So in Schedule 2, I would in fact place a contrary argument that the legislative intent is in perfect harmony. The legislature is very clear, my lady, that you have to take the exam, the written exam, that is A. That is the present. This is your present test, the written exam. 2, academics is your past. The marks you got before and the teaching you had before, because I'm very sorry, we did wrong to these 13,000 candidates who have been fulfilling their job dutifully and with honor and honorably. Now, 3 and 4 is subsequent to the written exam then, oral interview, lecture demonstration. Now, in the scheme of how you assess, when do you take these 10 marks of prior teaching experience, my lady, even if you see the scheme of the schedule, it has to be before the interview. Because the interview process, any interview in service law, any interview to public employment for a public employment position is the culmination. It's a pyramid. You show that you have the basic qualifications here, educational qualifications. You show that you have cleared prior to that the written exam. You show that you have, in this case, prior teaching experience, and you culminate that with the interview. The interview process and system, the panel for the interview, will have the least number of candidates because the sifting starts from the base of the pyramid upwards. You never have in service law the situation of a funnel. That is what my friends are asking for. If they ask for the prior teaching experience to be considered at the interview stage or after the interview stage, they are asking for this diagram. And that is unknown in service law because the interview is expected to be the culmination after your documents have been verified. I'll take my lady to the rest of the statute, which shows when is the verification done. Because after all, one way of verifying is in fact also checking that I am employed by the court, by the education system, to assess the fact that I am employed and therefore I have experience that is recognized by the statute. It is not any experience. It is experience which the legislature in their wisdom chooses to recognize. Now, my lady, part B. May I read, my lady? Okay. Selection to the post of assistant teacher for classes 11 and 12 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration determined by the Central Commission in the following month. Now, please see, my lady. It's almost identical, but when we go page over 548, you will please see under prior teaching experience 10 marks, it simply says at the secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks for each year of service in a substantive post. I will respectfully request my lady to underline this at the secondary level. And the secondary level is 9, 10, 11, and 12. Oral interview, lecture demonstration. Now see, please see. The distinction that is made by the legislature between the secondary level and the upper primary level. The upper primary level selection to the post of assistant teacher for upper primary level of classes shall be made on the basis of marks obtained on academic score, TET weightage, marks in written exam, marks in oral interview, marks for lecture demonstration, marks for prior teaching experience, to be determined by the Central Commission. So this segment of the schooling system is desegregated from the secondary level segment of the schooling system. So it's not everything that is put together, but it is secondary that is put together, and now this is upper primary.
No, upper primary is different.
After 5 till 8.
So 6, 7, and class 8 would be upper primary. 6,
5,
7,
6, 7, 8.
5, 6, 7, 8 would be upper primary. 9, 10, 11, 12 would be secondary. These are the segments. And this is the assessment that is done eventually by the interview panel, which is looking at everything that funnels into 9, 10, 11, 12. And that is distinct from upper primary level, which is 5, 6, 7, 8. And primary, of course, would be 1, 2, 3, 4. So these are the 3 segments of how education is also understood. And it is understood because it is also, there is science as to how children's brains develop. That is what it is, my lady. Now, my lady, may I take you? My lady, may I have a sip of water?
Yeah, sure.
Thank you.
Rationale,
Yes.
9, 10, 11, 12.
Now, my lady, as my learned friend rightly points out, in practice, and this is based on conversations with the teachers, and we have also annexed some information on that. In practice, teachers of 9, 10 are often assigned 11, 12 classes due to vacancies and administrative limitations. So there is that kind of exchange that goes on. And they also serve as examiners or evaluators for higher secondary examinations. And this we have enclosed, my lady, in annexure C, page 22 of Can 1.
In the Biswajit Biswas.
In Biswajit Biswas, which is writ petition number 25015 of 2025.
Can 1 Biswajit Biswas. Can 1 of Biswajit Biswas. Access.
Yes, yes. And when I give my written submissions, I'll extract all of this for my lady. So it's all in one place.
Yes, what is it
Yes.
that you want
Now,
to rely?
My lady, I'm sorry.
What is it that you want to rely?
Only this, that within that realm of 9, 10, 11, 12, there are a lot of duties that are inter se exchanged in that category
right.
of teachers. That's
All
it.
right.
Only to that extent. And we'll extract it when I give you my submissions. Now, my lady, what is the law when it comes to prior experience? This because I've shown that prior experience is categorized. It sounds very logical. Well, what is the law on it? And this is the law that I'd want to take you to. Firstly, my lady, and we've given this append in on page 485 of this compilation. The UGC, छोड़ दीजिए, कोई बात नहीं, ठीक है, छोड़ दीजिए, group discussion भी छोड़ दीजिए.
485.
485. The UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in higher education. These are the regulations of the UGC 2018. May I just take you to page 485? The regulations start at page 435, my lady. My lady has that? 435. Page 435.
Yes.
Within the compilation. This is the UGC regulations on minimum qualifications for appointments of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education. So this pertains to all UGC regulations all over the country, my lady, as it pertains to the central government. Now, from this, and my lady will see an exercise of powers conferred by the University Grants Commission Act. These are the minimum qualifications for appointments of teachers. This is a macro at an all India level. Now, please see, and the short title, application and commencement, these regulations can be called so and so. They apply to, my lady has this 1.2.
Yes.
They apply to every university established or incorporated by or under a central act, provincial act, or state act. Every institution, including a constituent or affiliated college recognized by the Commission in consultation with the university concerned under Clause 1 of Section 2 of the University Grants Commission Act 1956, and every institution deemed to be a university under Section 3 of the said Act. So you can see the remit of it. Now, may I take you to page 485 of this, table 3A. My lady has this 485, middle of the page. Criteria for shortlisting of candidates for interview for the post of assistant professors in universities. Please see serial number 7 on the same page. Teaching, postdoctoral experience, 2 marks for 1 year each. This is prevalent. This is upheld. I'll take you to case law. So my lady, may please just mark this page. And this is at a national level, that this prior teaching experience is given and accorded preference to. And this, my lady, was upheld. I'll take you straight away to the case. Allahabad University, page 188 of the compilation. Page 188. So, yes, relatively new case, my lady, 2024. SCC Online, SC 376. Justice Dipankar Datto writing. So if my lady goes to page 190, you'll see exactly what has been challenged, what I read to you. As per clause 7 of tables 3A and 3B, 2 marks are to be granted to a candidate for every year of his or her teaching experience or postdoctoral experience. Since the contents of both the tables are similar, we propose to reproduce 3A later in the judgment. So exactly what I read to you. Now it's being tested before a bench headed by Justice Datto. Now, please, may I take you to page 215. Paragraph 45.
Page 1.
15, paragraph 45. Now, this is the conclusion on the test. Even otherwise, we find no my lady has this.
Yes.
Even otherwise, we find no justification to uphold the view taken by the division bench of the High Court. It was never the intention to deprive aspirants of marks for their teaching experience as assistant professors, albeit for shortlisting purposes. So, for shortlisting purposes. So, 2 things are happening here. 1, you are saying that you will give that experience, and 2, you are using that experience to shortlist. The pyramidal structure with the interview being the culmination. Now, please, I'll continue. Conditions of eligibility for entitlement to secure marks, which have been laid down, are matters of policy over which the courts have no expertise. Judicial review would not extend to cases of the present nature where regulations are framed by experts having a fair measure of idea of what is required and what is not for appointment of teaching posts. The division bench overstepped its limits and treaded a territory which was forbidden. Now, may I take you, my lady, respectfully, to paragraph 47. Page over, my lady. Page 216. May I read?
Yes.
Above, we have assigned reasons why the High Court was not justified in its approach. Independent thereof, there is one equally weighty reason for allowing the instant appeals. As discussed in MP Public Service Commission, I'll take my lady to that. A recruiting authority is well nigh entitled to adopt a method for shortlisting candidates on some rational and reasonable basis where selection is required to be made only on the basis of an interview. In the present case, note to Regulation 4.1 relating to assistant professor ordains that after shortlisting of candidates based on academic score, again, this is the same language, academic score specified in tables 3A and 3B, the selections shall be based only on the performance in the interview. So once you have culled all of this, you have arrived at your shortlist in the language of Justice Dato, you then invite these shortlisted candidates for the interview. In the course of hearing, we were informed by learned senior counsel for Allahabad University that 69 candidates were shortlisted and called for interview, the cutoff marks being so-and-so, who were competing against each other for appointment of only one unreserved vacancy. Respondent 1 had secured 81 marks, and between 87.17 and 81, there were 147 candidates. I'm just reading this paragraph because I'd like to take you to the end of the paragraph, but I just want to be fair and read the whole thing. It is true that these facts and figures are not on record, but appointment in furtherance of the advertisement dated so-and-so date having been made, the High Court directed that the appointment already made need not be reopened. It is for this reason that we do not disbelieve the instructions provided to learned senior counsel for Allahabad University. However, considering the disproportionate number of applications received in comparison to the number of vacancies available to be filled up, Allahabad University narrowed the zone of consideration by adopting a marking scheme in the way it did, with the obvious ultimate objective of permitting candidates with higher teaching experience to enter the zone of consideration. This methodology was perfectly in sync with regulations 4 and 10 read with table 3A. The division bench, therefore, ought not to have been swayed in its decision-making process by reason of teaching experience not being a mandatory eligibility criterion. It is not mandatory in this process either. It just gives you more marks if you already have it. Now, my lady, may I just take you to 186, my lady, of the compilation. 86. And this is Maharashtra Public Service Commission versus Sandeep Shriram Varade. And the case starts at page 182. My lady has that?
Yes.
This is Maharashtra Public Service Commission versus Sandeep Shriram Varade, 2019 6 SCC 362. What am I doing? May I take you straight away to paragraph 9? Paragraph 9. Before I read the paragraph, may I say this, that in the case before my lady, the 2025 rules were promulgated in exercise of the power conferred under section 17(2)D, read with section 8 of the West Bengal School Service Commission Act. These provisions permit the state to make rules defining the manner and scope of selection of persons to be for appointment to the posts of teachers. I'll just repeat that. These provisions permit the state to make rules defining the manner and scope of selection of persons for the position of teachers. Now, please see what this means in terms of jurisprudence. Paragraph 9, page 186. My lady has that. The essential qualifications for appointment to a post are for the employer to decide. The employer may prescribe additional or desirable qualifications, including any grant of preference. It is the employer who is best suited to decide the requirements of a candidate that the candidate must possess according to the needs of the employer and the nature of work. The court cannot lay down conditions of eligibility, much less can it delve into the issue with regard to desirable qualifications, being on a par with the essential eligibility by an interpretive rewriting of the advertisement. questions of equivalence will also fall outside the domain of judicial review. And my lady, I'll just stop here to make the point just that there are 3 points that have emerged. That one, it is outside of the realm of expertise of the court to assess what is an acceptable qualification. Because that is what my friends are agitating. Two, yet the court can assess if the objective is a rational one or not, rational and reasonable. That is the Constitution's mandate. And three, why is this the case? Because the court may not be able to understand, though the court understands much more than any other institution, my lady. But in the case of what is best suited for a particular job, the employer understands this best. And why is that the case? Please, let's go to the next level. Why is that the case? Because the employer sees the functionality of the positions year in and year out, gets data from the ground, and then brings that up in the context of number of vacancies and the criterion for appointment. My lady, now I'd like to trouble my lady by going back to the division bench decision, my lady. And that's, we've annexed it in the compilation itself. So my lady doesn't have to move between files. It's pages 349 to 353 of the compilation. And this is the division bench's judgment, my lady. May I just read?
Is it in Arunima Pal?
Yes, my lady.
Right.
This is in Arunima Pal. Page 349. And paragraph 34.
Yes.
My lady will just mark this paragraph. I'll just read it very quickly. And I'm only on assessment, expertise. That's all, my lady. The awarding of 10 marks is an weightage to be given on the basis of experience. And it is only expected that in a selection process of this nature and kind, all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. Now, my lady, I want to stop here for a minute. This is the level of assessment that courts must go into. Is it arbitrary? Is it not? Is it rational? Is it not? This is the classical examination that Article 14 mandates that a court must get into. So a division bench does that. Step one of the assessment. And that is the final step of the assessment. It is the first and final step. If a court of law, and I'll just move away from this judgment. If a court of law, any court of law, when confronted with a regulation, a statute, a provision, or state action, feels that the aims is rational, then the court stops the assessment at that level, especially in the context of what is a suitable employment criterion or qualification. Now, please see. The object, I'll continue, my lady. The object is to select and appoint an experienced teacher. As rightly pointed out by the Learned Advocate General and Mr. Bandyopadhyay, appearing on behalf of the Commission, the appellant writ petitioners are not coming within the purview of categories in whose favor benefits and concessions have been extended in paragraph 49 of the judgment of the Honorable Supreme Court. They are not the candidates selected in the 2016 recruitment process. In the meantime, they have also not applied for service in any educational institution. It shall be the duty, and I'll just stop with these 2 lines, duty and responsibility of the state to ensure quality education, and the eligibility criteria should be framed keeping in mind the interests of the students. So these are the ways that a court, this paragraph, the division bench, is actually pointing to how must the court assess whether the objective is rational. How the court assesses is, well, what would be in the best interest of the child? It's a very good way of assessing whether it is rational or not. Of course, outside of this test of rationality, we have the peculiar and unfortunate situation that the court is confronted with. Untainted, 13,000 untainted teachers who, for no fault of theirs, had to take an exam twice over, and of course, hired lawyers from this state, outstate, to in fact make this point that we are bona fide candidates who are fulfilling our obligations, who have discharged our duties honorably, and are being forced into the rigors of litigation twice over and thrice over. My lady, I will only need another 20 minutes. And we can do this today or tomorrow morning, as my lady.
Today only.
Very well. Now, my lady, I'll take you to Satyadev Bhogar versus State of Rajasthan, which is, my lady, unfortunately, we have now a second compilation for my lady, based on what we heard on Friday, my lady. So we can't claim all credit for it. You have this? Huh? That's the only copy we have. Yes, yes. Yes, copy. You can airdrop a soft copy. Satyadev Bhagor versus State of Rajasthan. My lady, the case starts at page 14 of this second compilation. 2022 5 SCC 314. What is this about? Yes. Now, my lady, on page 14 itself, there is a very brief rendition of the facts, just to give my lady a sense of what this case is about and why I'm citing it. Because I'd like to examine what constitutes intelligible differentia that bears a rational nexus to its objective. This is the Article 14 test. My friends previously earlier in the morning have agitated that Article 14 and I believe 16 were being violated. So to answer that, on page 14, placentum C, my lady, these are the facts. Policy of the state of Rajasthan to restrict the benefit of bonus marks only to such employees who have worked under different organizations in the state of Rajasthan and to employees working under the National Health Mission schemes, National Rural Health Mission schemes in the state of Rajasthan cannot be said to be arbitrary. So these are bonus marks being awarded to employees who have previously worked under different organizations in the state of Rajasthan. Now, may I take you, I think disturbing the court. Not this. May I take you to para 15, page 19. So this is where the bonus marks, in some ways it is similar, my lady, giving an enhanced preference for prior work experience. That is considered to be relevant because we are on the point of intelligible differentia. Please see, may I read, my lady? Page 19, placentum E. It is trite that the courts would be slow in interfering in the policy matters unless the policy is found to be palpably discriminatory and arbitrary. This court would not interfere with the policy decision when a state is in a position to point out that there is intelligible differentia in application of policy and that such intelligible differentia has a nexus with the object sought to be achieved. Now, the division bench in Arunima Paul says what is in the best interest of the student. Now, please see para 20. How do we complete this understanding of intelligible differentia that bears a rational object? Please see para 20. Page 21, placentum B, C, D. It could thus clearly be seen that the division bench in Jagdish Prasad, after considering the record, has come to a finding that government of Rajasthan had conducted several training programs for persons working with it on a contractual basis as well as under different schemes. Now, if you come to the last 4 lines, I don't want to trouble my lady, but it's on prior training and experience. The division bench, my lady has that, 4 lines from the bottom, has clearly held that the experienced candidates in other states cannot be compared with candidates working in the state of Rajasthan, as every state has its own problems and issues, and the persons trained to meet such circumstances stand on a different pedestal. We are in complete agreement with the aforesaid observations of the division bench. We find that the policy of the state of Rajasthan to restrict the benefit of bonus marks only to such employees who have worked under different organizations in the state of Rajasthan and to employees working under NHM, NRHM schemes in the state of Rajasthan cannot be said to be arbitrary. On Article 14, my lady, if my lady could just mark this. Therefore, my lady, the state's objective of recruiting the best teachers, because it is the best teachers that are in the best interest of the child, is directly correlatable to having teachers with more experience. And on this, on prior experience itself, I'll only trouble you with one more case because that case has all the other cases on prior experience, which my lady will need. May I just take you to Mahesh Chandra Barrett versus State of Rajasthan. And it starts at page 22, the next page of this short compilation. (2024) 8 SCC, page 124. And this case is one relatively recent, 2024, now Chief Justice, sitting with Justice Vishwanath. And may I take you to para 34, my lady? Para 34, page 34. What the Supreme Court, speaking through this bench of judges, does, my lady, is it culls various cases that they have adjudicated, where in each of these cases, prior work experience, prior teaching experience has been held to be a valid criterion. It is valid intelligible differentia, and it is a valid rational object for the state to engage in. Similar to the case before my lady. And these cases are, I'll only just list them out because they're so similar to what is before my lady. Para 34, Srinivas K. Gowda versus Karnataka Institute of Medical Sciences. What is the case here, my lady? Please see. At the time, eligibility and requirements were prescribed. At the time of selection, the selection committee decided that out of 15% marks for interview, 10% of marks were to be set apart for the length of work experience and or additional training in teaching hospitals of the medical college, with special preference to those who had worked in teaching hospitals of government autonomous medical colleges, and remaining 5% were to be assigned to the personality of the candidates based on viva voce. Similarly, page over, my lady will see Srinivas K. Gowda. Para 9, this is what the court extracts. It is in this background that we need to determine whether the marks allotted to the appellant in the category of experience and personality are arbitrary. The appellant at the time of submitting the application had 1 year work experience in Bapuji Medical College, so-and-so, and 3 years work experience with the first respondent. On the other hand, the respondent at the time of the application had only 6 months experience of working under a doctor who was undertaking private practice. Not only did the appellant have more years of work experience, he had work experience in a governmental institution. Hence, the marks awarded to the third respondent and the appellant bore a nexus to the yardstick determined by the selection committee. It is not the case of the third respondent that the appellant was given more marks for experience despite having less work experience. On a comparison of the marks allotted to both the candidates with reference to the yardstick determined by the selection committee, no mala fide could be imputed to the selection committee, nor is there any obvious or glaring error or perversity. The court does not sit in appeal over the decision of the selection committee. Both those points, my lady. On 1, prior work experience being a relevant criterion. 2, prior work experience being intelligible differentia, bearing a rational nexus with the aims and objectives, are the best interests of the student. And 3, a court must not sit in appeal over the decision of a selection committee. Now, my lady, I'm not going to read all the other cases, but they are entirely similar, and my lady will take my word on that. Satyadev Bhagor, which we just read, we went through in some detail. And then finally, Satyadev Bhagor continues, and we find the ratio, para 40, page 36. We find that the ratio laid down in the said judgment is applicable to the facts of the present case, as also to uphold the action of the state. So the contemporary jurisprudence in the last decade, when the court, the apex court, is seized of prior teaching experience as a criterion of preference or priority or enhanced eligibility, 1, has been upheld by the court. 2, not just in the realm of the court feeling it doesn't have expertise, but 2, in the realm of it being intelligible differentia bearing a rational nexus with a legitimate objective. So the court feeling that 1, yes, that it satisfies Article 14 and that mandate of Article 14, and 2, that the court feeling that beyond a point, as long as that first threshold is satisfied, what my lords in the division bench and Arunima Paul say, as long as that first threshold is satisfied, the court must not traverse further because of lack of expertise, etc. Now, my lady, the last point I want to make, and I'm very grateful for a patient hearing, that the 10 marks allocated for prior teaching experience is to be awarded respectfully before the interview stage. On this point, my lady. Now, my lady, there are 2 parts that I'll trouble my lady with. 1, I'll take my lady to Rule 11, which I've got in the compilation. And 2, I'll also deal with the linguistic conundrum that was before my lady about 2 weeks ago also. Academics and academic, both these 2 facets. Now, my lady, may I just take you to page 541 of the compilation itself? It starts at 537, Government of West Bengal School Education Department. These are the rules. Yeah. Now, my lady, may I just take you to middle of the page, 541. method of SLST for selection of candidates and preparation of panel. Now, the rules in question, my lady, is on the following page, 542. And I'll start with 1110, Roman 10. This is on page 542. Now, this is step 1. Step 1 is Roman 10. The preliminary list of the shortlisted candidates prepared by the Central Commission shall be forwarded to the respective regional commissions. This is step 1. This is the preliminary list of the shortlisted candidates prepared by the Central Commission. Step 2. This is 11, Roman 11. Thereafter, so this is subsequent to 10, the regional commission shall verify the credentials and eligibility of the shortlisted candidates appearing for interviews vis-a-vis their applications prior to conducting the interview. So please see the language of this. The regional commission shall do what? Shall verify the credentials, the degrees, the past conduct, my lady, that I dealt with in Schedule 2. Shall verify the credentials and eligibility of the shortlisted candidates appearing for the interview vis-a-vis their applications prior to conducting the interview. So the applications whose credentials have been checked and found incorrect by the regional commissions, and the candidates who are found ineligible to participate in the selection process shall not be allowed to appear for the interview. Absence of a candidate during verification will automatically disqualify. Now, the application itself asks the candidates, the existing teachers included, to mention their prior teaching experience. So this is step 2. And the step 3, my lady, is 12, which has to do with the context of disability, if any. I'm not here on that at all. Now, step 4, which is Rule 15, Roman 15, my lady. This speaks to the interview list. Now, please see, this is after step 1, step 2, step 3, step 4. Thereafter, my lady has this, Roman 15. Thereafter, the Central Commission shall prepare a consolidated interview list, which shall be published and be forwarded to the interview board as specified in Schedule 3. Now, it is very important, my lady, may I respectfully request you to mark 2 portions, to underline 2 portions of this. The Central Commission shall prepare a consolidated interview list. This is one part of this clause, which shall be published and forwarded to whom? This is part 2, to the interview board. And how? This is specified in Schedule 3. So this assumes that all the information, the documentation, the verification, the marks, the weightage of Schedule 2 has been accomplished before we get to the interview. The interview list being the culmination of this process, which starts with writing the exam, and in the case of untainted teachers includes their past conduct, which the second schedule I read to my lady. Now please see the final step, step 5. This is Roman 16. My lady has it. This is the final stage on the same page. After interview, the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list, and on the basis of the report of the interview list, prepare and publish a merit list category-wise on the basis of merit as per Schedule 2. The merit list shall contain the names of all eligible candidates who have appeared for the interview. So, my lady, respectfully, this is the top of the pyramid. So the rules envisage, all service law rules, my lady, envisage the interview to be the culminating process. There is no realm of understanding of qualifications of any sort of this being a funnel, which is what my friends are asking for. They are asking for the interview to be in the middle of the process, not at the top, which defies rational objectivity. If, in fact, this prior teaching experience were to be assessed after the interview, the state's policy would be rendered irrational, unintelligible, and open to my lady then setting it aside on this ground. For the policy to be rational as it is, the schedules contemplate and the rules contemplate that the interview is the culminating final point. After assessment of all the documents, the past conduct prior to this second round of examination, leading up to the interview process, to see, essentially to see the personality. Can this person communicate? Person has expertise, person has qualifications, the person has marks. And I was astonished, my lady, I'd like to show you this and take only 2 minutes. I want to show my lady the qualifications, the PhD, all of that we went through, of the candidates, of the teachers. Because what I wanted to show, they should have got copies. What I wanted to show, my lady, is this, that the 13,000 untainted teachers who are before my lady are actually quite extraordinary, because in the morning I was going through, well, who are some of them? Many of them are PhDs. Some are PhDs from IITs. This is the nature of who is teaching and also the nature of the pandemic, that is unemployment in this country. To then take this valuable resource that I have fought so hard. I was looking at the number of PhDs in that list that my friends showed me. There were hundreds of PhDs, from maths to chemical engineering, IITs. It was extraordinary. Electrical engineering, so on and so forth. This is the nature of how qualified and how in need they are of these jobs. And this is the nature of who teaches in government schools. To take these candidates who have manifold proven themselves in terms of educational qualifications, who have manifold proven themselves in terms of fulfilling their obligations and duties, because you had a taint process, to make them redo this twice and maybe be terminated from their jobs for no fault of theirs, really begs the question then, my ladies, of whose fault this is. It is certainly not the fault of 13,000 untainted, honorable, duty-bound teachers who come to my lady for justice. I'll end there. I'm very grateful for a very patient hearing.
Please,
Right. In today itself?
It's already 4:21.
Yes, that's the reason I.
You should see in the first document, no? Just a short points. before
My lady,
the
there's just one small point. I'm sorry. There's just one small point. This was on that point of
Academic.
academics and academic,
Yes.
which has come up before, my lady. I'll just finish that. I'm sorry. I keep interrupting you. Please forgive me. I just wanted to take my lady back to the schedule. Academic score and academics, page 538 of the schedule.
definition.
Now, and I'll just end with this. I'm sorry. Please see 538 subclause K, interview list. In respect of SLST state level selection test means in cases of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score, score from written test and or TET for upper primary, and academic score in the ratio of 1:6:1 of final vacancies. So this is the context of academic score. Please see, so rule 2K and 2L, which then explains what is this merit list. I'll just read that. And then I'll take you to the schedule, which uses the word academics. May I just read this? L, merit list. In respect of SLST, state level selection test, means in cases of posts, a list of candidates prepared category wise on the basis of merit, which shall mean, in addition to what has been stated in Rule 2LK, marks obtained in oral interview, lecture demonstration, and prior teaching experience shall include all the eligible candidates who have appeared for the interview. So the merit list, my ladies, includes all of this. This is the final culminating merit list. Now let's please see the schedule. And the schedule 2 is on 547, which is academics. My lady has that. Now, academic score, my lady, which is what is used in K, simply pertains to define what it means in the context of grammar. It just pertains to define what it means in terms of my academic score or my marks in the written exam. This is all it means. And it is made clear when you see the schedule, which has academics, which is plural, and that is on page 547, academics. And academics is plural because it has manifold criteria of what constitutes academics, as in my academic accomplishment, which invariably for a student will be multiple subjects. For a person who wants to become a teacher will be all of this criterion. So this is academics. What is my academics? What is my expertise and excellence in academics? So one, expertise and excellence, would be educational qualifications, 10 marks. 2 would be prior teaching experience. And these would be the 2 criterions for which I would then culminate with an academics score. So my lady, I don't find this to be anything in terms of this is only English language, where in one context it is being used as a noun, and in the other context it is just being used to score, academic score. In a certain, there is no dissonance between the schedule and the rules as I see it. And I'll just stop with that. Thank you, my lady. I'm very grateful. And my lady, at the end, we'll hand over written submissions
All right.
when my lady reserves judgment.